Item 1.
Yes, please.
Pardon, my lord.
Sorry,
On-
kindly speak to the microphone, please. Yes, please.
Yes. My lord, in item number 1, I adjourn this matter on behalf of the Krishna Chandra
Your name, madam?
Priyanka Jana. P. Jana.
Miss Priyanka Jena for the petitioner. Here it has been mentioned for to be taken up.
But he's now out of station.
Though the matter is taken up on mention, the Lord and Counsel for the petitioner seeks accommodation due to non-availability of the arguing counsel. As prayed for. List on.
List after vacation.
Yes, it will go. It has to. Further. 1-11-2023. Yes.
Item 2.
May it please, Milas.
Yes.
Milas, first of all, Milas, a deep sense of gratitude, Milas, to having this.
Wait, actually, I'm not sure that whether I'm able to. I'm not controlling anything. It's for the registry that they are able to
Yes, Milas,
list it.
so grateful. Milas, this is a rate, Milas, challenging the jurisdiction of an authority which has been newly constituted. This is the authority called National Financial Reporting Authority,
Yes.
which has come into effect by way of section 132(1), which came into effect on 1/10/2018.
Yes.
Malats will kindly have page 17. 17.
Yes.
Malats sees the notification by virtue of which the NFRA
Yes.
was constituted. May I place Malats, page 17?
Yes. The cause of action is arising at Delhi, as at Delhi or at
Cuttack. Yes, Malats, because
the farm is at Cuttack.
yes, Malats.
Okay.
And your lordship will see the notification, Malats, page 17. May I place, Malats? In exercise of the powers conferred by section 1, subsection 1 of section 132 of the Companies Act, the central government hereby appoints 1st October 2018 as the date of constitution of NFRA. Malats, for brevity, I'm referring it to as NFRA. Malats.
Yes.
Then, Malats, the powers of NFRA with respect to imposing punitive actions, punitive measures, that came into effect by virtue of section 132(4). Now, Malats, your lordship will see the next page, page 18, the notification, Malats.
Yeah.
Malats sees 24th October 2018. Your lordship sees which all provisions came into force. This, in exercise of the powers conferred by such and such, the central government hereby appoints 24th October 2018.
So there was a proceeding before this particular authority.
Yes.
So where you have taken that stand that this authority doesn't have a, you show that, and how they have dealt with it.
No, Milords, my humble submission is, I candidly submit, Milords, that particular aspect regarding jurisdiction was not taken.
So that candid admission in law has a huge ramification.
I completely bow.
Because you submitted yourself.
Malats.
You submitted yourself to the jurisdiction, yes, but what you are saying is correct. That lack of jurisdiction being inherent.
Yes, I am so grateful.
But I understand that, but unless so, the problem is that now this court is not in a position to assess your stand, first thing.
Again, only on jurisdiction.
Yes. What is your stand? I am unable to assess because you candidly admit or fairly submit that no stand is taken. Second, once you have not taken,
Milords,
the appropriate authority, as you say, that though without jurisdiction, they proceeded.
Milords, your lordship is correct.
And they have also not looked into that aspect.
Yes, your lordship is absolutely right. But
so,
may I humbly
so let me issue notice and admission.
Milords, may I just make some further submission, Milords?
Yes.
Your lordships, my not raising, your lordships, I bow down to the fact that this point of jurisdiction was not raised. But Milords, my humble submission is my not raising the submission regarding jurisdiction, Milords, will not amount to bestowing jurisdiction upon NFRA.
Correct.
Because there is no estoppel against law.
Otherwise, the writ petition should be dismissed in limine.
Well, yes.
The only arguable point you have that there is a complete lack of jurisdiction.
Please, Milords.
So,
I'm so grateful.
So let them. Let them respond.
Yes, Milords. Only request, Milords. Here, what is the ramification of that order? An order which is completely beyond jurisdiction.
No, completely beyond jurisdiction. Realized off late. So please complete.
Realized off late. I bow down to that observation, Mulats. I realized off late, but Mulats, it is without jurisdiction.
So you show your written statement before that authority.
Yes, Mulats, that reply was filed on merits, not in jurisdiction.
No, I understand.
Yes, Mulats.
Please show that.
Yes, Mulats, the reply, Mulats, is at page 77.
Yes.
Dealt with all the articles of charges. Mulats, this is 3/12/22. Mulats will see.
You have not answered the principal allegation actually.
Yes.
You have not answered that.
Principal
That your appointment was defective.
Yes, Mulats, that has been answered.
No, you read a too small a.
No, Mulats, there is a detailed at page 79. What a table करके हमें reply दी थी.
No. You read 2A.
Yes, Mulats, 2A.
77.
Yes.
Don't miss that. Then you will miss that in your argument also.
DHFL videos letter dated 23/8/27.
Requested the farm. So now you see the order, impugned order.
I'm sorry, Mulats.
Now you see the impugned order at 97.
Mulats, before your lordship goes there, if your lordship
No, you don't.
reply re achi.
The change this approach of directing the court when the court is requesting you to go through.
No, I'm sorry, Mulats.
Stop that.
I'm sorry.
Stop that. One Justice Jaswant Singh also said you that. Don't try to evade or avoid a query.
Yes, Mulats. I completely bow.
You are a quite capable lawyer. So I have all of us have lot of hope, including the bar.
Mulats.
So when a specific query, be attentive because it's a height of multitasking.
Mulats.
So you just see that this page 98, paragraph 2.
Yes, Mulats. NFRA's investigations revealed that the appointment of none of the 33 branch auditors was approved at the AGM of DHFL as required
by the act.
As required.
So you show me in your SOCUJ where you have answered this.
Yes, page 79. I have dealt with
straight away go to that line actually. Yes.
Yes, Mulats. 79, para 3. Failure to ascertain from the company whether the requirements of section 139 and 140 of the Act in respect of such appointment have been duly complied with, which I have replied. Section 140 of the Companies Act is regarding removal and resignation of auditors, which is not applicable in this matter. As far as Section 139 is concerned, as explained above, the primary responsibility of compliance of the same is that of the company, that is DHFL, since it was a continuation of previous year assignment. When the firm
still you have avoided to answer that whether the earlier year's appointment was as per the resolution, and mere wrong quoting of provision, say 139 and 140. You see, you are not answering. You are not answering that it is not a requirement. Just again, go back to that page 97, 98.
Yes, I'll go.
Appointment of none of the 33 branch auditors was approval at the AGM.
Yes, Mulats.
So that you have to say that it is not a requirement of law, that it is the approval is not approval has to be made by the AGM.
My humble submission
what
to
you
that.
are saying that 139 doesn't deal with it, 140 doesn't deal with it. And our appointment was a continuation of the last year's appointment.
Again.
Then your answer could be that yes, that's a valid point, very valid point, pertinent also. Last year's appointment was pursuant to the AGM.
Mulats.
Either this year's or last year's
Again.
is pursuant to the AGM. Have you stated that anywhere?
No, Mulats, that is not there. But Mulats, may I just
This is no answer.
May I just respond to that?
Yes.
Section 139 and 140.
That is well taken.
Yes.
You see, you distinguish the applicability of the section 139 or 140. That is not same as saying, that is not same as saying that appointment of the branch auditor of the 33 branches is not to be approved by the AGM. Please appreciate that.
Mulats, I completely bow down to your lordship. Your lordship may kindly allow me to respond.
No. The problem is that it's not a question of exactly a law. It's a question of mixed question of fact and law. No. Suppose they don't refer to any sections also, and still they say that this is a requirement. Then you have to answer that it's not a requirement of law.
No,
that's the point.
May I respond?
Anyway.
May I respond to that?
No. Since I'm already said that I'm issuing notice.
Only one request, Mulats.
Yes.
What is the outcome of the order, Mulats?
Whatever outcome of the order,
it is department.
You take notice.
Mulats,
take notice. You should have taken that hint. When you are unable to answer 98 paragraph 2, I'll reject the IA or I'll issue notice. I have two choices.
In
because you see,
I
Because
completely
you see
bow
a
down,
lack of jurisdiction, then you have to show that who is having jurisdiction.
my lords.
Third thing, that by complying with natural justice,
NAFRA came in only in October 2018.
who is having jurisdiction for
At that time, perhaps ICAI was having
whoever,
but NAFRA, my lords, is not the authority.
whoever,
It is, and in fact, my lords,
no, after the date, on the date of occurrence, whether NAFRA was there or not.
no, my lords.
What is the date of occurrence? When
Financial year 17-18.
no, the date of you being notified as the branch auditor.
Financial year 17-18.
Date, sir.
Date, my lords,
I are not responding to the query.
23/8/2017, which falls within
23/8,
financial year 17-18.
23/8/2017.
My lords, page 41.
So to 23/8/2017, you were notified to be the branch auditor.
My lords.
When NAFRA came,
1/10/2018.
1/10/2018.
Again.
So you saw that applicability of NAFRA?
Yes, my lords. NAFRA doesn't have any retrospective application.
No. The jurisdiction as far as the alleged incidents are concerned.
Yes, my lords.
Retrospectivity of the statute I am not asking.
My lords, section 132.
And definitely the statute will be retroactive because on that particular date when NAFRA was notified,
My lords.
there is no parallel jurisdiction. NAFRA is the only authority, or there is a parallel jurisdiction.
But, my lords, the statute says that it is.
Sir, again, the same problem. Whenever a question is asked, please try to answer that. Don't ask a further question. Question is very specific. The day NAFRA came into existence, on that day, NAFRA is the exclusive authority or any parallel authority is there as far as the pending matters are concerned.
There is no pending matters, my lords. No pending matters. NAFRA initiated this. After 4 years.
You are not getting the question. I am not asking regarding this particular company or the institution. I am asking in general question.
My lords.
From the date of designated, whenever a court is designated or an authority is designated,
My lord.
all the matters get transferred to that authority. That authority acquires jurisdiction.
My
It
lord.
may be SAT, CAT,
Again.
or any also court of jurisdiction, like your company court,
My lords.
Commercial Court Act. On the date, like company court has a cut-off date.
My lords.
So that was the question, that whether
I am answering that. my lords.
Yes, please.
The answer to that, my lords, is to your lordship's query is that as on date of NAFRA coming into
Sir,
existence.
you are not getting the question again. I am not asking whether this particular matter was pending on that date.
No, my lords.
So that I know. That I don't have to ask you to know, understand.
My lords.
So that is how I answered your proposition to make you realize that I understand that on that particular date, this cause of action was not there.
Yes.
But the question is very specific,
My lord.
that whether for the existing cause of action, NAFRA has authority or not. My understanding is that definitely NAFRA has the authority because there is no other authority. But anyway,
ICAI was the authority.
anyway, if you want to insist for an interim order, I have to reject that or I will issue notice.
My lords, sir.
And I will give these reasons.
My lords, khali gote jin, sir. Similar matters before Delhi High Court, Telangana High Court, sabuthre entry order deichat.
Could be.
So,
Could be.
and on this idea, because ultimately what is happening,
Could be.
it is retrospectively levying a penalty.
No.
Punitive action.
Don't bring the tax here. Don't bring tax here.
It is.
No penalty is levied here. He stopped from accepting as assignments.
And my lords, what will happen today to all my existing clients?
Heaven will fall. Your submission is that by this interim order, heaven will fall. I can record that, but I'll reject on these grounds. Because once you started arguing, you must realize that why the court is asking.
My lords, I am answering your lordship's all queries, my lords.
No, you have not answered. That I'll record. If you want, I'll record that what you have not answered.
My lords, the answer to your lordship's
You
query.
see, you have not answered paragraph 2 as far as 98 is concerned. Nowhere in the reply.
In fact, my lords, I started off saying
Not jurisdiction. Not jurisdiction. No, I'm not asking jurisdiction. I'm not asking jurisdiction. You know what I asked you.
my lords, may
Because
kindly,
you are saying that
kindly for a moment. My lords, will have a look at the order.
98 paragraph 2. Paragraph 2 now, no, you see, interim order has no binding precedents.
No, I
Please
completely
appreciate. Please appreciate
completely
that I am not going to, unless I hear them, I will not grant interim order.
my lords,
You have to be more patient than your client.
yes, my lords. I
So for a short
completely-
notice, I think they are appearing on advance notice.
they're-
My lords, I have
they're-
received the
they're-
notice, my lords.
Bring him on. Yes, you are appearing here.
Yes, my lords. I have received the notice. My lords,
So would you respond to the IA?
my lords, let me give this short
What is your
advice.
submission? What is your submission? You have heard-
Because of paucity of time, my lords, we could not take any instruction. We have asked for it, my lords. We
It
have.
was filed only yesterday. I know that.
Yes,
I know that it was only filed yesterday. We could not have taken because
I
even
completely
that.
bow down because that was
Lordship, if you
yesterday.
do, any shortest possible date, my lords, we'll.
So what do you say to his response? That is it not this order is. He's saying that you are I mean depriving of his livelihood.
No, my lords, that.
ଗୋଟେ request करते ठीक है.
Let him respond. Again, you are requesting.
आगे. Nine.
Please be more patient than your client at least.
ठीक है.
Yes.
My lords, I just pray, my lords, the shortest possible date may be given.
So yeah, he's not submitting.
ମୁଁ ବୁଝୁଛି sir.
So now physically and in virtual mode, actually there is no point in probing him further prodding him to give an answer.
Only thing, Millards, if subject to your lordship's kind consideration, Millards, may I pray let there be an interim order, Millards, at least.
Sir, I could not get it.
Millards, if your lordship will kindly permit Millards to make this submission, Millards,
Always permitted that I have never restricted anyone.
Millards, if your lordship will protect me at least till that.
No,
your lordship.
you see.
On the question of interim relief, Millards, your lordship
suspension and or deprivation for it is a temporary stoppage. It's a temporary stoppage.
And the other thing, Millards.
Sir, do you mean to say that I'll pass an interim order stopping you for 1 year? So that stoppage will be for the time he is seeking.
Yes, ma'am. Yes. Only for that time. Till the time my learned friend responds.
No.
If your lordship will kindly protect me.
No.
Tara actually
I will take a order on merits because though courts usually don't do that, but I'm making you aware that yeah. I will observe that.
Khali gotte jinsa mu khali.
No,
if I may
then for your insistence.
No, I'm not insisting.
IA 16853 of 2020.
Millards may kindly have it on reopening, Millards. That's what I was requesting.
Don't disturb the interim order. I have to now observe.
No, Millards, I was requesting for having it on reopening.
You have requested. I have to pass the interim order. IA number 16853 of 2023. The learned counsel for the petitioner. First the writ petition.
Let my learned friend take instructions, plus.
Issue notice on admission. Since Mr. Prabhu Prasanna Behera, learned CGC, has appeared on advance notice, no further notice be issued to the how many opposite parties?
Millards, only Millards, Union of India and NAFRA.
You are appearing for OP number 2.
Yes, my lord. Both.
Since Mr. Prabhu Prasanna Behera, learned CGC has appeared on behalf of the opposite parties, let 2 extra copies be served on the learned counsel. How much time you will like to file reply to the?
Within 2 weeks, my lord.
But it will be taken up for interim order as he's pressing for that.
Your lordship, yes.
As prayed for, list on today's 19th. List on 26th and 2nd. List on 6/11/2023. For the opposite parties to place on record their response to the petition. IA. The learned counsel for the petitioner, those orders you. Yes, only. 15 order anantu. Be attentive. The learned counsel for the petitioner seeks for an interim prayer to the effect that the operation of the order dated 29/9/2023 under Annex 13 pending disposal of the writ petition shall be stayed. For consideration of the interim prayer, this court specifically asked the learned counsel for the petitioner.
My lord, let the interim relief be considered on the next date.
No. That
I was
taking chance or with a
no, I was just
some
requesting.
limitations.
I was just requesting to have it short date. That's what I was not pressing, Millards, any further.
Before you said that, I told that.
Again, say your lordship have this
counsel for the petitioner was
for the consideration of interim prayers.
Before the authority where the issue of lack of jurisdiction was raised in the response of the petitioner, as it is, and it is apparent that no such plea was taken before the authority. As observed in paragraph 2 of the order dated 29/9/2023, NFRA's investigations revealed that the appointment of none of the 33 branch auditors was approved at the AGM of DHFL as required by the Act. The learned counsel for the petitioner was also specifically requested to point out if there was any AGM for appointment of the auditor in the AGM of the DHFL. The learned counsel in response submits that the appointment was for the last year, that is the financial year 15-16, and it was carried on to the next year, that is 16-17, and it was carried on to 2017-18. It is also not brought to the notice of the court that for the financial year 2016-17, there was an AGM to appoint the 33 branch auditors as required by the statute. The learned CGC in response submits that since he was served copy yesterday after filing of the writ petition, he shall obtain instructions, and the interim prayer may be considered on the next date as prayed for list on 6/11/2023. Yes.
Data mela se Telangana ro eta.
They have gone on to analyze whether retrospective application or not.
Yes, yes. Say it.
Submission and note korantu, the learned counsel for the petitioner submits that in the writ petition, that the authority, that is NFRA, National Financial Reporting Authority, doesn't have jurisdiction as it came into effect from
AK-10-18.
from AK-10-18, and the allegations made against the petitioner.
Okay. For financial year 17-18.
No, dates are again your financial year.
Again, appointment is of 23/8/17.
The appointment is of year 23/8/17 for the financial year 2017-18 ending in
31st March 2018.
31st March 2018. Yes, that is the submission. Then issue notice.
Item 3.
Yes.
3-4 is same, Milots. Identical facts, 3 and 4.
Dates
Same, absolutely the same.
DHFL is same.
Same.
I mean the organization is same.
Again.
So Bhukta, you are there along with
In three, I am appearing. In 4, my friend.
so 3, Mr. Diptiranjan Bhukta, CGC. Mr. B.S. Maharana. Mr. B. Maharana in item 4.
3 chartered accountants were appointed by DHFL.
Yes.
So say 3 jana hochen 2-3-4. Item 2-3-4. Identical.
But I think Mr. Acharya, you should.
Milots.
Yes.
Great.
Item 5, may I please your lordship? My lord, offence 376-2N, 294, 323, 374, 506 IPC. My lord, earlier petitioner came before filing the charge sheet. The presently come after charge sheet. Answer 3, BLPL 8580/23. Allegation is that petitioner kept physical relationship with victim and torture of the physical and mentally. 164, not specific allegation, my lord. 164, Annexure 1, page 33. ମୁଁ ଶିବାଶିଷ ବେହେରାକୁ ନିଜ ଇଚ୍ଛାରେ ଭଲ ପାଇଲି। ଆମେ ଘରେ ରହି କହିଲୁ ଏବଂ ମୁଁ ଉଭୟଙ୍କ ଘରେ ରାଜି ହୋଇ
Mr. Tripathi, can you please listen? So please be attentive when you are appearing in the VC. Please be attentive. You are looking down and reading. You are not, maybe I have switched off, but please be attentive to the response of the court. There
Yes,
are two accused persons here.
No, one accused person.
Then why there is a connected?
Shivashish Kumar Behra.
Kindly wait, Mr. Tripathi.
My lord, sole accused, my lord, there is there. My lord, the bail application of the present petition was there before the Honorable Court, and it was disposed of on 510. Since the counsel for the petitioner, my lord, prayed that it was a rejection of pre-charge sheet, he take the leave of this Honorable Court, and this matter was disposed of. Thereafter, they moved before the London trial court, and the bail application was rejected again on 910, my lord.
Okay.
That is at.
So have you got the 164 statement?
That 164 statement, he has annexed page 33, your lordship may consider.
Case diary?
Case diary is not there.
So
Because
you
it
have
was there in that file, my lord, that file.
So can you get that record?
Just now?
Yes. From your office. I'll just pass it over.
I'll try. Well,
Mr. Tripathi, please wait. I'll
Yes,
take
sir.
it up at 11, say 11:30.
my lord.
Yes, sir.
Yes.
Item 6.
Kindly adjourn after vacation.
Your name, sir?
Sisir Kumar Samal, SK Samal.
Sisir Kumar Samal. Mr. SK Samal for the petitioner. Yet again praise for adjournment. Though it was granted on 31/7/2023, 21/6/2023, 9/5/2023, 11/4/2023, on 11/4/2023, or full stop then, on 11/4/2023, the Learned Counsel for the State was directed to obtain case diary. The Learned Counsel for the State again reiterates his submission that case diary is available. He has criminal antecedents.
My lord, no understand.
No.
What is the quantity?
Yes, my lord, he used to contain 230 kg. My lord, from the exclusive possession, my lord. And
The case diary is available. As prayed for by the Learned Counsel for the petitioner to grant another further opportunity to the petitioner, list on 8/11/2023. Yes.
7.
My lord, may I pray for
Mr. Pradhan,
my lord.
your name is Mr.
Sorry, my lord.
Kabiraj Pradhan.
My lord.
Sorry, my lord, ଆପଣଙ୍କ ନାଁ କ'ଣ?
Sorry.
Mr. Kabiraj Pradhan, on behalf of Mr. S. Ponda, Learned Counsel for the petitioner, Mr. Standing Counsel for the State, Learned Counsel for the petitioner seeks accommodation on ground of personal difficulty. Though earlier accommodation was granted on 2/9/2023, 30/8/2023, 14/7/2023, 1/6/2023. Case diary is available.
yes,
To grant another opportunity to the petitioner, to grant a further opportunity to the petitioner for the fifth time. The matter is adjourned to 3/11/22. Or you want, what is the date he is suggesting?
May pray 2 weeks after. In the week commencing 13th, my lord. 13th November.
As prayed for?
14.
For the fifth time to 14/11/2023.
Obliged, my lord.
The Learned Standing Counsel submits that case diary is available. There are eyewitnesses accounts.
solitary eyewitness.
There is a solitary eyewitnesses against the regarding the incident alleged against the petitioner. Yes.
Item 8.
Item 8, my lords, may kindly grant a password. My seniors on his list.
Today there is a difficulty as far as passing over the matter is concerned. Because there are no more petitions, so and
My lord, let them file the affidavit regarding the local security, my lord. That,
I have prepared an affidavit, Your Lordship. I'm filing it in court.
and if the copy, solve the copy, I'll take the instruction. My lord.
you serve the copy, you file it in the registry. You file it in the registry so that it can be updated. I have an issue regarding including in the scanned copy. So unless you file it in the registry, it can be scanned and updated.
Lordship.
Are you getting, sir?
Lordship, I have filed a physical copy. I'll do that with the registry.
Physical copy, the learned counsel for the learned counsel for the petitioner submits that he is filing. You are Mr.
Anshuman Rai on behalf of Sri
Mr. Anshuman Rai on behalf of Bhavani Shankar Das Parida for the petitioner.
on behalf of Sri D.P. Pal, Senior Advocate.
Please never mention to be on behalf of Mr. Learned Senior Counsel. You can engage a senior counsel. You can't appear on behalf of a senior counsel. Has filed affidavit indicating that local solvent sureties have agreed to stand surety, have agreed to stand as solvent sureties for the petitioner in the event he is granted bail by the Honorable Court, by this court. The copy of the affidavit is served on the learned standing counsel, who shall obtain instructions by after local inquiry, a thorough local inquiry by the concerned police stations. Police station into bracket small s. By what time you can get it?
Lord, your lordship may call it after 1 week after the vacation.
Mr. D.P. Dhara, instructed by Mr. So-and-so, senior counsel.
Well, it can be given to the lower court for verification. Well, it will be better for not that. Why we will verify here in High Court?
No, the problem is that then there is a difficulty for the petitioner. If the local court is not satisfied, then he's left nowhere. Then again you have to move this court, because technically the bail is granted by this court.
Well,
so this affidavit copy will be produced there.
Well, for verification.
For verification.
Or else, my learned friend was showing an order. That order can also do suffice the purpose.
So it was a standing counsel also.
Yes. Good many conditions are there. Considering the fact that yes, it's there. Copy.
No, I'll serve extra copies to my.
No, so that he can go through now.
Yes, ma'am. I will. I am sorry.
Just give it now. I think regarding mobile number and location, that there is an order by the Supreme Court that it is not possible. Yes, he knows that.
Is the number. That is the order passed by the local court, this the High Court.
Yes, but the Supreme Court has not has not supported this view.
Bombay High Court.
There is a recent order by the Supreme Court that there is an order that he will give his mobile location and all that.
That may be added. Extra condition.
So if the order is passed that after verification, the learned court in season of the matter shall pass the appropriate orders, imposing terms and conditions.
Yes, Lord.
Yeah, that can be.
That can.
So that can be, I think that.
If it is found to be correct, my lord,
and after hearing the learned counsel for the petitioner as well as the learned
yes.
Regarding the conditions to be imposed. Mr. Dhara, after hearing that will be imposed.
Yes. The document will be verified by the learned.
Senior counsel, Mr. D.P. Dhara, instructed by Mr.
Anshuman Rai.
Anshuman Ansuman Rai, Mr. Standing Counsel for the opposite party. Mr. Misra, your matter item?
Item 11.
You have filed the same affidavit.
Another affidavit I'm filing. Another, my lord, because he is the son of the, he is another person.
No, local surety have you filed? Indicated.
Yes.
Just check the affidavit of the London senior. Mr. Roy, please show that affidavit.
Copy not.
Same. Table kari dej. I have also given table.
His name
and Aadhaar card. Aadhaar card.
And the details has also been annexed. Because now you must realize that one person will be bail will be allowed with these conditions.
Yes, madam.
So it has to at least that minimum that parity should be maintained. In your case, those conditions have to be imposed. So for that you have to file identical affidavit.
I'm doing just now. I'm filing within half an hour, my lord. It's a similar form, but same much almost. But I can file it also.
Okay.
Absolutely similar. So the similar order will be passed away.
Okay. The affidavit. Affidavit filed by the wife of the petitioner, dated 19/10/2023. This is by Mr. Misra. This is Kiran Devi. Is your client?
Kiran Devi, my client.
Acha. So this is in order. It is the same thing, but he has annexed. You have not annexed.
Well, I am not annexed because.
So fine. You just because annexes don't require attestation by the notary.
Yes, ma'am. That if you
annexers require attestation by the concerned lawyer. So you file the annexers. In the
I have done it.
Then Potta.
I have done it before, my lord. Oath commission, my lord.
I understand. Oath commissioner does not put his stamp or signature in annexer.
Annexers.
Annexer is not part of the affidavit also. Annexer and index.
Yes, ma'am.
So you enclose those documents. Are you having those documents?
No, my lord, online protection.
So you get that. In fact, they should send it to you on. The affidavit by this is BL Appeal 6243 of 2023. Affidavit by one Sri Ramji Sukla, son of so and so, address so and so, who is the paternal uncle of the petitioner, has been filed, wherein at paragraph 2 the following has been stated. Para 2 and 3 the following has been stated. The learned counsel for the learned senior counsel appearing for the petitioner submits that the petitioner shall abide by all the stringent terms and conditions that would be imposed for grant of bail, and he may be shown indulgence in view of the fact that charge sheet has been submitted on.
My lord, it was submitted 2 months before it.
Yes, that's a preliminary charge sheet.
Whatever. Final charge sheet. 20 final report 21/8/2023.
Final prosecution report has been submitted on
21/8/2023
by the Court of Jurisdiction.
My lord. JMFC Bossa.
Okay, I am not elaborating. So yes. And Mr. Dhola, that day you said that it's a final. It is not yet open.
My lord has also verified it.
My lord does.
Final police report has been submitted.
Yes, my lord. Okay. This copy, photocopy, certificate copy is
not necessary. It is submitted that the petitioner shall abide by all the terms and conditions that would be imposed to ensure his presence to be subject to the jurisdiction of the learned court in session of the matter. The learned standing counsel, referring to the materials contained in the case diary and the nature of allegations, submits opposes the prayer for bail. Subpara, however, comma, it is not disputed at the bar that the final charge sheet has been submitted. The final police report has been submitted. Para. Having heard the senior counsel for the petitioner, the learned standing counsel for the state, considering the material on record, the
My lord,
The affidavit dated 19/10/2023 filed by the near relative of the petitioner. This court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter. Which shall also include a condition that any deviation from violation of any of the terms and conditions shall lead to filing of petition for cancellation of bail by the investigating agency, disposed of accordingly.
my lord, may I kindly
My lord, one more condition.
record my objection looking at the gravity and outsider raises the objection, my lord.
Yes.
My lord, one more condition can be imposed, my lord.
No, all the conditions.
No, with regards to this affidavit,
Yes,
we are filing.
That I'm observing. After that, you right.
My lord, otherwise, my lord, we
Since
do not know.
since the affidavit is filed before this court, the learned today, the learned court in session of the matter shall be
Shall very
कौन लिख ले sentence টা? Since copy of the affidavit filed before this court today shall be produced before the learned court in session of the matter. The court through the investigating agency shall verify the contents of the affidavits regarding the local sureties as stated therein, and only after being satisfied and compliance of all the terms and all the preconditions and terms that would be imposed by the learned court in session of the matter, the petitioner shall be enlarged on bail. Next, your matter is
Item 11, my lord.
11, same order.
Same order,
Sir,
my lord.
Saugat Das.
Yes, sir. Instead of my lord, wife, there will be mother. Mother has filed an affidavit.
That has to be changed by looking at the affidavit. Here, mother of the petitioner. Item 11, Srimati Kiran Devi, then wife of so and so.
In my
Yes, of
case,
so and so.
paternal uncle.
Mother of the petitioner. Ramji Shukla and Kiran Devi are to be written with their details. Yes. The affidavit in item 11 is dated 1910. Upon dekhi likhon. Yes. Yes. Yes, please.
Item 9.
Item 9, may I please, Lordship?
Yes.
There are two items, Lordship. In the first item, I am here, Lordship.
Yes, please.
Last occasion, in fact, flag K is an affidavit filed by the petition, Lordship, showing his offer and interest for group. But the
Mr. Rajesh Kumar Mahapatra.
Lordship.
Or likely, further. Sorry. It item kete? Item 9. Mr. Rajesh Kumar Mahapatra for the petitioner. Mr. Standing Counsel for the state. The learned standing counsel, the learned counsel for the petitioner refers to the affidavit at flag K filed by
The petition, son of the petitioner.
by the son of the petitioner. When at paragraph 4 and 5, the following has been stated.
Yes.
It is submitted that the learned counsel, it is further submitted by the learned counsel for the petitioner that the statement made at paragraph 4 can be the precondition for release of the petitioner on bail para. It is further submitted that the petitioner, being a person having roots in the society and a local resident, there is no possibility of he escaping the jurisdiction of, evading the jurisdiction of the court in session of the matter. The learned standing counsel has been served with a copy of the affidavit.
Yes, my lord. My objection is that the amount, my lord, which has gone to his account, my lord, 16 lakhs 43,000. In my lord, in return of
The
that,
learned
my lord,
standing counsel submits that amount of rupees 16 lakhs.
16 lakh 42,000, my lord.
42,000 has been allegedly credited to the account of the
And
petitioner,
cash of rupees 24 lakhs
and the cash of rupees 24 lakhs
38,000, my lord. From 25
the
investors.
petitioner, and there is a further allegation that cash of rupees 24 lakhs
24 lakhs 38,000 from 25
38,000.
years. 25
24
investors.
lakhs cash of about 25 lakhs have been received by the petitioner
From 25 investors.
from about 25 persons. Having heard the learned standing counsel opposes the prayer for bail. Having heard the learned counsel for the petitioner, the standing counsel for the state, considering the material on record, particularly the affidavit dated 17/10/2023, filed on behalf of the petitioner through his son. This court is inclined to grant bail to the petitioner subject to such stringent terms and conditions, including the precondition in terms of the precondition that the petitioner would be precondition as stated in the affidavit at paragraph 4. That before the learned court before the learned court in session of the matter, the petitioner will deposit a cash of rupees 2,50,000 along with property surety to the tune of rupees 15 lakhs. This court is inclined to grant bail to the petitioner. Please read the sentence.
In the second item,
The conditions are also the stringent terms and conditions that would be imposed as would be deemed proper, fit and proper by the learned court in session of the matter shall also include a condition that any deviation from violation of any of the terms and conditions shall result in filing a petition for cancellation of bail of the petitioner, disposed of accordingly.
so in the second item,
You have to use the word further. When you start this, further conditions shall be imposed. Yes.
Grateful.
in the second item,
Sub-item,
same, I have filed the affidavit.
Mr. P.K. Nanda.
Yes, sir.
Your name, sir?
Devasis Sahoo, D, sir.
Mr. P.K. Nanda along with Mr. M.S.Sahoo for the petitioner. Affidavit at flag. R. Please always look at the cause list so that and be quick in your response. The condition is you have served a copy on the standing counsel.
Yes, sir. I have solved.
Yes. Here it is, paragraph 3. It is 3. Not actually it is stamped, so not 3. Cash of rupees 3 lakhs without prejudice to the rights and contentions of the petitioner. He shall deposit sum of rupees 3 lakhs as cash surety and property surety worth rupees 12,000. The learned Court in session of the matter after due verification. And after further imposition of any such terms and conditions that would be deemed fit and proper, shall allow the petitioner to be released on bail along with a condition that any deviation from violation of any of the terms and conditions shall result in filing a petition for cancellation of bail by the investigating agency.
Well, that contention in that previous order regarding money misappropriation in respect of the present petitioner 1,32,000 malad cash malad in the account and cash of rupees 12 lakhs money. 12 lakhs more than 30.
Then he being afraid of you, he's giving 3 lakh and 12 lakh. So why should you? Then there should be no condition, further condition. Being scared of you, though he's attributed 1,30,000, he's giving 3 lakh. And property is giving 12 lakh.
Let it be there because the total misappropriation.
No, the opposition, your opposition after getting more cash security and property security.
My friend Tripathi client is in Malad.
The first matter, yes, I understand that you are saying, but in your matter, the next matter, he is scared and he is giving more.
My lord, absolutely.
So what is the opposition to that?
At the last reason was offering 1 lakh, my lord. When I cited, actually,
so why should you object that?
No, I'm not objecting, only my lord formal objection.
Rather, you should say that in view of the petitioner exceeding the alleged amount.
Thank you so much.
No, that should be your submission. It should be fair, my lord.
He's always trying to protect the interest of state.
No, it has to be. It has to be. I mean, he has a brief in his hand.
Right.
It has a brief. He has a brief in his hand.
We are dealing. Grateful Lordship for this order. May I pray for a copy, perhaps?
Urgent copy. Urgent certified copy as per rules.
Grateful.
Item 10.
10, my lord. Lordship, keep it the matter today, my lord, to file a affidavit of the.
Yes, you must have marked those matters. The last 2 matters also, similar matters. They filed. But it's not yet filed.
Not yet filed.
You are already, father from has come all the way. He has filed affidavit by giving an amount that
survey copy.
You saw already survey copy, my lord. I told him,
6 lakhs cash security, Mr. The way you are threatening somebody, 1 lakh allegation, he is depositing 3 lakh.
Since he's a retired teacher, who should not.
No, not only that, that is another thing. But it is a cash security, Mr.
My lord. My lord.
Mr. Milan Kanungo, senior advocate, instructed by Mr. Siddhartha Das for the petitioner.
Informant also there.
Mr. Standing Counsel for the state, Mr. Smrutiranjan Raut for the informant. The learned counsel for the petitioner refers to the affidavit dated 1910-2023. In all the matters, actually, the affidavit is to be taken on record. That order has to be there. Affidavit is to be taken on record. The scanned copy and the case brief shall be updated. Learned counsel for the petitioner refers to an affidavit dated 1910-2023, filed today, and submits that the petitioner's father has been advised to file this affidavit to seek indulgence from this court. The affidavit be taken on record, scan copy and the case brief be updated. It is submitted by the learned counsel for the petitioner that in terms of the paragraph 5 of the affidavit, the petitioner has been advised that a cash surety of rupees 6 lakhs shall be furnished and property surety of the rest amount as alleged. Here the amount is
Here the amount is, my lord, petition more than.
আছে তো 13,11,000 ଥିଲା rest
Yes, my lord. Two prisoners that there, my lord. Not 13. More than, my lord,
around 14 lakhs
14 lakhs.
because he's what lakhs?
Achha.
To furnish cash security.
My lord, more than 16 lakhs.
সেটা
অঙ্ক ভুলে গেলাম। অঙ্ক ভুলে গেলাম।
Unless that is about 16 lakhs shall be furnished to the satisfaction of the learned court in season of the matter as a precondition for grant of bail. It is further submitted that petitioner is a local resident having roots in the society and there is no possibility of he escaping the jurisdiction of the learned court in season of the matter. The learned standing counsel, referring to the contents of the case diary and the allegations, opposes the prayer for bail. However, it is not disputed that charge sheet has been submitted on final prosecution report has been submitted on 7/7/2023. In Mr. Rajesh Mahapat's matter, he did not give the date.
Charge sheet date.
Just let me complete this. Then I will get those dates. Or you ask him to give the dates. 7/7/2023. Para. Having heard the learned senior counsel for the petitioner, Mr. Standing Counsel for the state, the learned counsel for the informant. The learned counsel for the informant ko submission lekhantu. The learned counsel for the informant also vehemently opposes the prayer for bail, referring to the allegations. Then you write, having heard the learned senior counsel for the petitioner and Mr. Das, senior counsel for the petitioner, and Mr. Standing Counsel for the state and the learned counsel for the informant, this court is inclined to grant bail to the petitioner. Subject to such terms and conditions, stringent terms and conditions that would be imposed by the learned court in season of the matter, along with the condition as stated and indicated in the affidavit dated 19/10/2023, filed on behalf of the father of the petitioners. Here there are two petitioners. It has to be plural petitioners. That a cash surety of rupees 6 lakhs to be furnished, and the amount of rupees 10 lakh as property surety shall also be furnished before the learned court in season of the matter. The conditions for grant of bail shall also include a further condition that in case of deviation from violation of any of the terms and conditions that would be imposed shall result in filing a petition for cancellation of bail by the investigating agency.
May I suggest, my lord, that 6 lakhs will be kept in a fixed deposit amount with a regular.
No, without prejudice. Deposited in the court.
That will be.
So what they are doing, I don't know what is.
You're not understand.
You are sharing a concern. That's good. What is happening? I don't know. It is kept in a current account. But you file a move a petition to because the court. I don't know what is exactly the provision in the GRCO. After 20 years in a Mata case, the 5 lakh rupees deposited after 20 years almost still remains 5 lakh.
I understand.
Because it is a decretal due. Here it is not a decretal due. It is a deposit. So it should be invested in the learned court shall have the liberty to invest the amount of cash deposited in a interest-bearing fixed deposit with auto-renewable clause.
In any nationalized bank.
In any nationalized bank.
Well, out of record one term conditional or my lord, after release of the my lord petition, they will pay back the money to their father, my lord, because which small
that Mr. Maharaj, you have been asking otherwise that I cannot impose that condition. He is the person who is asking because it but in view of the Supreme Court order.
That is voluntarily file affidavit.
Bappa kete
So I'm being educated by the bar every day. So recently, in view of that Supreme Court order, he has been telling that that condition.
Yeah, added. Hon'Ble.
ବାପାଙ୍କୁ ପଇସା ଫେରେଇ ଦବ ଏଟା ଟିଚର ଲୋକ କେତେ କଷ୍ଟ
That is a pious obligation now. The father for his two sons is arranging the money and see. Yes, please next.
Item
Yes, Mr. Pikyananda and Rajesh Mahapatra.
yes my lord that charge sheet date is 31/7 my lord.
Item 9. Charge sheet submitted on 31.
31/7.
And prosecution report submitted on 31/7.
23
2023.
yes
Yes. Yes.
Item 12.
Maybe the item 12 can permitted to withdraw, my lord.
So where he is now? Where is the accused now?
Custody, my lord.
Custody, my lord.
To obtain instruction?
My lord.
You have any instruction, Mr. Mahapatra?
Yes, my lord. Case diary is available.
He is in custody, or I could not understand the whole sequence of events actually.
No,
That's the,
Lordship had called for report from the Lord Court below whether he had released on entry bail or not in spite of the order passed. But he is saying that last occasion he was saying that he has not upheld the interim order.
he said that I could not furnish bail bond.
Yes, my lord.
The learned court says that he never moved that.
There.
Yes.
Oh.
Where is he?
Report is there.
Then he is inside the custody, my lord. Lordship, in view of the rejection order.
No, he has to be. But he has to be, but in this maze, that kind of wave they are spinning,
Yes.
at times you will also be confused what is exactly is happening.
No, my lord.
The statement that he could not furnish bail bond is apparently not correct. He has never taken advantage of that 17/7 order to move the court.
Yes, no.
Then what is the reason? Then why the bail was granted and why it was directed that he shall be?
I have to obtain
Yes,
instruction from
yes.
the concerned jail, my lord.
Yes, jail and the IO.
IO. Yes, ma'am.
Yes.
He has to inquire into and to submit a report.
This a statute in Miss Mohini Sahu on behalf of you have power, Miss Sahu.
Because his
my lord.
conduct is like this, my lord. 2006 case, he was absconding. Subsequently, of late, he was apprehended.
So you just verify.
My lord, I'll in touch with my lord, the IO and also the concerned jail.
On 17/10/2023, the following order was passed. Ms. Mohini Sahu, Mr. S.S. Mahapatra, Additional Standing Counsel. In response to the direction of the court to obtain instructions from the District of Sambalpur, from Learned ADJ, Learned Additional District and Session Judge Kuchinda through the District of Sambalpur, the report has been received, wherein the learned district judge, the learned additional the learned district judge by letter dated 18/10/2023 has indicated the following. Letter number 5148.
His custodial certificate, my lord, I am obtaining from the concerned jail.
Okay.
It will show to which period, my lord, he has been.
So you quote the entire this thing. In view of this, the learned counsel for the learned standing additional standing counsel shall do well the obtain a custody certificate of the petitioner at present through the from the jail. Also instructions shall also obtain instructions from the concerned IO.
My lord. as well as
The report furnished by the learned district judge shall be kept on record. Scanned copy and the case brief shall be updated. List on
minor item 5 da.
Just a second. Please wait. Please wait. I'm dictating on. List on. 8 नो जल्दी रखिए ना 1-11 for orders. That other BLAPL file could you get?
here in this case?
No, Mr. Praraj.
Yes, sir.
Yes, your matter. Please call item 5.
Item 5.
May I please your lordship? My lord,
No, I have heard you. So I wanted to. I'm just looking for the case diary.
And 164 statement is there, my lord, and the CCTV footage where the victim was assaulted by the present petition was there. See that CCTV footage.
How
was
CCTV? How CCTV? Which place it is?
My lord, the allegation is that during the all those things she has been assaulted by the present petitioner, and there was injury on the mouth, my lord. Lips. I'm sorry, lips.
Mr. Ashutosh Tripathi for the petitioner, Mr. Standing Counsel for the state, the learned counsel for the petitioner being present in the virtual court of the Orissa High Court at Hon'Ble addresses arguments. It is submitted by the learned counsel for the petitioner that in view of the fact that charge sheet has been submitted on Mr. Tripathi.
That is there with my file.
Submitted and so date. Dash. The petitioner is entitled to be granted bail. It is further submitted that the petitioner had a relationship with the victim. Therefore, he is entitled to be shown indulgence by this court for granting him bail. The learned standing counsel referring to the materials contained in the case brief. Opposes the prayer for bail. This court has the occasion to go through the case diary furnished by the investigating agency. Having heard the learned counsel for the petitioner, the learned standing counsel, this court is not inclined to grant bail to the petitioner at this stage. Accordingly, the same is dismissed at this stage. Yes. Yes.
Item 13.
May I please, your lordship,
Yes, please.
Here I am in custody on 27/9/2023. Last
Yes.
two order.
My lord, I'm sorry. That charge sheet order is 21/7/23.
21/7/2023. Yes. Last order. Date of charge sheet.
Can
21/7/2023. Yes, please.
can have a glance at the order dated 4/10 as well as the 17/10. And here that my submission that the zonal manager of this financial institution, Muthoot Finance Limited, Lodge and Affair, I being the relationship manager of the Miller on Jharsuguda branch, I along with other staffs Miller.
How much money? Yes, you are saying that you have not misappropriated any money.
Any money?
There is no allegation in the FIR.
Not Miller.
Yes, my lord. That is
The allegation in FIR Miller, look into FIR, running page Miller, 9, second paragraph. Miller. Our company is also running under so and so Miller rules and regulation RBI guidelines. Our company is a finance company. Our company is providing loans to poor females for their empowerment.
No, sir, you are stuck there. You are just, I mean, you must understand the query.
Yes.
What is the allegation regarding you receiving the money? What is the, as on record?
As on record, my lord, allegation.
How much money you have received?
I have not received a single part.
What do you say?
What he did, my lord, he is a branch manager of the Muthoot Finance Corporation, my lord, of the local area. For my lord, processing the loans, my lord, he did process the loans of the minor people, my lord, those who are not eligible to receive the loans, my lord.
So that is an error of judgment.
And
that you may remove him from job, but how do you say that he has misappropriated the money?
That amount, that.
So where is that allegation in the FIR even?
My lord, FIR, that has.
So like he received, you see, you must be hearing today.
Yes.
All the matters are of economic offences.
Yes.
They have received cash, they have received in their account. There is no allegation.
No, through account that has not been true.
Cash,
that is no.
Any allegation, anyone paid him anything?
No, that is not, but he gave loans, my lord, to undue persons. Those were, my lord, by.
Sir, that is the error of judgment. Sir, he can't be, I don't think, though I am not supposed to express opinion on merits of the case.
Yes.
Where is this element of he appropriating the money?
No, my lord, that is not. My lord, he processed the loan to the person.
Yes, loan processing that. And you see, in any financial institution,
yes,
not a single individual never approves any loan.
Yes.
That all of us know, because since we are depending on that for purchases of our,
and by which, my lord, it is alleged he has caused loss to the bank.
Yes, causing loss can be a good ground for disciplinary proceeding. But where is the criminality as far as accepting money is concerned? Or suppose a special statute is there where it says that yes, somebody who has assessed the document, so he is criminally liable.
No, what happened, my lord? In FIR, it has been alleged that submitting the false documents, but that when the IO issued notice, Lordship, on the last occasion, Lordship desired to know the financial implications. My lord, in spite of several notices to the concerned, the informant, he is the regional
Mr. Mahapatra, and all of us know that what is the financial implication of as far as bad bank loans are concerned.
Yes.
Bad dates.
No, he is
in our country. It's a big thing.
Yes. He is not turning up. Even complainant is not turning up to provide the.
Then you have to say that. You see, Mr. Mahapatra, even a very worst case scenario, assuming that the money was not transferred to their account.
Yes, that is there.
Then where he has
that is on record, my lord. That is not disputed. But
Mr. Amulyaratna Ponda for the petitioner, how much cash security you will give?
My lord, please.
Because your lauded seniors have gone to the extent of 3 lakhs, 6 lakhs. Property of 10 lakhs. Somebody who has the allegation is of 1.1 lakh 30,000, he is giving 33 lakhs. That is the trend today.
Lauded seniors ko jodi 6 lakh khala more hajur ke kam hobo.
No, upon that instruction you can't negotiate there, na?
No. And apart from that,
anyway, stringent terms conditions subject to the satisfaction.
Yes.
Mr. Amulyaratna Ponda for the petitioner. The learned counsel for the petitioner reiterated his submissions as noted earlier that petitioner has not misappropriated any money as alleged. The final police report has been submitted on 27/9/2023, wherein it is indicated that the informant did not produce anything to indicate that the petitioner had received any money. The final police report copy has been served on the learned standing counsel.
I have also obtained, my lord, the
learned standing counsel will also obtained up-to-date CD
along with this instruction, specific instruction with regard to the financial impact,
which is in sync with the submissions of the learned counsel for the petitioner. The learned counsel for the petitioner submits that the petitioner being a local person, there is no possibility of he not submitting to the jurisdiction of the learned court in session of the matter, and the petitioner shall abide by all the stringent terms and conditions that would be imposed. The learned additional standing counsel opposes the prayer for bail, referring to the materials contained in the case diary. Having heard the learned counsel for the petitioner, the learned additional standing counsel for the state, considering the material contained in the case diary as well as the up-to-date instructions furnished by the investigating agency, the court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in session of the matter, disposed of accordingly.
14,
Mr. Nrsingananda Mahapatra for the petitioner, Mr. Additional Standing Counsel S.S. Mahapatra for the state. Yeah, antecedents?
One antecedent 395-307.
The learned counsel for the petitioner submits that the petitioner is in jail custody since
11/3/23.
11/3/2023. In the meanwhile, charge sheet has been submitted on
Charge sheet submitted, my lord.
on that so and so date. The petitioner shall abide by all the terms and conditions that would be imposed for grant of bail. He being a local person, stop. He being a local person, having roots in the society, shall not evade the jurisdiction of the learned court in session of the matter. Charge sheet filed on
21st May
2023. The learned additional standing counsel referring to the instructions contained in the case diary furnished by the investigating agency opposes the prayer for bail. Also, the learned additional standing counsel referring to the past allegation against the petitioner dated 28/3/2023 regarding the alleged offences under section 341, 323, 294, 506, 307, 394, date with section 25/27 of Arms Act, corresponding to city case number 1945 of 2022, pending in the file of learned JMFC Bhubaneswar. Having heard the learned counsel for the petitioner, the learned additional standing counsel for the state, considering the material on record, considering the material contained in the case diary and the affidavit filed on behalf of the wife of the petitioner, this court is inclined to grant bail to the petitioner subject to the terms and conditions, stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also contain a condition that any violation of deviation from any of the terms and conditions shall result in filing of the petition for cancellation of bail by the informant, victim, law enforcement agency, disposed of accordingly. Urgent certified copy as per rules. Yes, please. Next.
15,
Yes.
May I please?
Yes, please. Yes. Yes, Mr. Sodangi.
Last time I was saying, my lord, I am inside. 10 ଲକ୍ଷ ଟଙ୍କା ଯୋଗାଡ଼ କରିକି ଦିଆ ହେଲା ଆଉ 6 lakhs ଦବା କଥା. Not able to arrange unless I am out. ଜମି ବିକିକି ଦେବି କି କେମିତି କଣ କରିବି, I don't know. And I have got 2 daughters.
No, have you stated that given a chance you will clear that dues? in your
that's it, sir.
affidavit.
In any case, my lord, I have already deposited. He wants.
No. Here it is a peculiar case. I am talking here not about the cash surety or the property surety. I am talking about the loan due of the bank, which is admittedly the bank has given you disbursed the loan to you.
That I was showing, my lord, 6 lakh something.
Exactly. So that is how in that context.
That amount I will pay, your lordship.
Mr. Santanu Kumar Sodangi, senior counsel for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. Santanu Sodangi, senior counsel, instructed by Sudip Sodangi. And Ms. Gayatri Patra for the informant. When the matter was taken up on 16/10/2023, the following order was passed. Order ta quote kar debe. It is submitted by the learned counsel for the petitioner, senior counsel, that given a chance, the petitioner, if granted bail, shall clear the dues to the bank by how much time?
1 month will be reasonable.
Within 1 month from the date of release. Within 6 weeks from the date of release.
680, if your lordship is
694.
6,80,000.
I don't know what is the up-to-date interest. I cannot say.
Oh, 694.
If the petitioner is granted bail, he shall date of release. The learned it is further submitted that the petitioner shall abide by all the stringent terms and conditions that may be imposed for grant of bail, comma, he being a local person having roots in the society, shall subject him to the jurisdiction of the court in session of the matter. Para. The learned additional standing counsels referring to the contents of referring to the materials contained in the case diary opposes the prayer for bail. The learned counsel for the informant again reiterates her submission that behind her back, behind the back of the informant, his property has been mortgaged by the petitioner to secure a loan, out of which about rupees 8 lakhs remains outstanding.
6,94,000.
About 8 lakhs remains outstanding.
About 7 lakhs, my lord.
The learned counsel for the, it can be about 10 lakhs also, sir.
No, certificate they check those.
Sir, about, when you put in word about, it can be the, so please don't join issues there. About 8 lakhs remain outstanding, and the petitioner, the informant has been put to unnecessary harassment by the activity of the petitioner. In response thereto, the learned senior counsel reiterates his submission that he will clear the dues of the bank within 6 weeks after he is granted bail from the within 6 weeks from the date he is released on bail, if granted, if granted. Having heard learned counsel for the senior counsel for the petitioner, having heard learned senior counsel for the petitioner, the learned additional standing counsel for the state, the learned counsel for the informant, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition, as has been stated at the bar today, that the petitioner has been advised to clear the due of the bank within 6 weeks from the date of his release on bail. It shall further contain a condition that any violation oblique deviation from the terms and conditions, any violation of oblique deviation from any of the terms and conditions that would be imposed shall result in filing of petition for cancellation of bail by the learned by the informant oblique urgent certified copy as per rules.
Okay,
Yes.
16,
May I plead your words?
Yes, please.
And charge sheet has been submitted. And here is a case. Initially, FIR was lodged under 307, my lord, and subsequently 307 has been deleted from the charges, my lord. And it's a dispute, my lord, within family
So,
members.
you have paid for withdrawing the petition.
No, my lord. My lord, meantime, my lord,
Yes.
my lord, charge sheet has been submitted, and it's a dispute within family members, my lord.
So there is eyewitness account.
Injured statement is there.
Ajay, he has himself stated that he was attacked. Attacked with what?
Yes. He has stated.
Yes.
ମୋ ଘରେ ପଶି ଗାଳିଗୁଲଜ କରିବା ସହିତ ମୋର ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଏକ ଖଣ୍ଡାରେ ହାଣି ରକ୍ତାକ୍ତ କରି ତଳେ ପଡିଗଲି। ହୋ ହଲ୍ଲା କରିବାରୁ ସେଇ ସମୟରେ ମୋର ସ୍ତ୍ରୀ ସଂଶୟ ଆସି ମତେ ଉଦ୍ଧାର କଲେ। ତାପରେ ଆସାମୀ ଗଣେଶ ପଡା ଗଲାବେଳେ ଧମକ ଦେଇଗଲା ଜୀବନରେ ମାରି ଶେଷ କରିଦେବି ପଣ କରିଛି। ତାପରେ ମତେ ଏମ୍ସ ନେଇଗଲେ। ବେଲେ ଡିଷ୍ଟ୍ରିକ୍ଟ ହେଡକ୍ୱାର୍ଟର ହସ୍ପିଟାଲ injury report given stating that the injury on the scalp and also that is grievous in nature. But the AIMS treated, AIMS gave the certificate that is not, my lord, that will not cause the injury, will not cause death. For that, the 307 was deleted by the IU. No, 307. No, 307 because it is not dangerous to the life. For that, to attract 307, 307 has been died. He is alive.
It's a 307.
307 case. My submission is, with regard to 307, only considering the report of the AIMS, that is not threat to life. Charge sheet is 307 to delete করছেন charge sheet. No, he is alive, lordship.
No, my lord, my lord is not audible, my lord.
I'm so sorry. Yes,
my lord. Here is a case, my lord. The petitioner, the informant, is the uncle of the present petitioner.
Sir, I'm not asking how they're related. I'm asking about the health condition of the injured. He has recovered and he is
recovered.
Okay. That is your instruction also.
Yes, madam. He has recovered.
Mr. Amlan Shakti Pal for the petitioner. Mr. Additional Standing Counsel S.S. Mahapatra for the state. Learned counsel for the petitioner. He is still in custody.
Yes, ma'am.
He is in custody.
Submits that the petitioner is in custody since
3/6/2023.
3/6/2023.
Charge sheet submitted on 20.
Charge sheet has been final prosecution report has been submitted on
27/8/2023.
27/8/2023.
Yes, ma'am.
Deleting 3
antecedents.
I have
antecedent. Though no registered antecedents are there, but he
the learned counsel also refers to the affidavit filed by the mother of the petitioner, which indicates there has been past allegations of criminal activity on 2 occasions under section 392 of IPC in 2018. Thereafter 399, 402 read with section -25 of Arms Act. You can in the year 2019.
90.
Regarding the submission of the petitioner, it is further submitted that in the charge sheet, the section 307 of IPC has been deleted.
Yes, ma'am.
The injured has recovered and is hale and hearty.
Ma'am.
The learned counsel for the learned additional standing counsel opposes the prayer for bail.
But in the case diary, his antecedent is mentioned like this. No mentioned PS case mentioned.
However, it is not disputed that. However, it is not disputed at the subpara. However, comma, it is not disputed at the bar that the charge sheet has been submitted and in the FPR, the final police prosecution report has been submitted, wherein the section 307 IPC has been deleted.
Yes.
Para. Having heard learned counsel for the petitioner, the learned additional standing counsel for the state, considering the material on record contained in the case diary submitted by the investigating agency, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also contain a condition that any deviation from violation of any of the terms and conditions shall result in filing of petition for cancellation of bail by the victim, informant, law enforcement agency, disposed of accordingly. Yes, please.
17.
17 after vacation.
Yes, Mr. Kamila.
Yes, after vacation.
No, there is an observation that the court is not inclined to grant bail. Mr. J. Kamila for the petitioner.
After vacation, after vacation.
Sir, please be particular in your submission. I am referring to a order passed by this court. The learned counsel for the petitioner seeks for adjournment. On 16/10/2023, after hearing the learned counsel for the petitioner, the following order was passed. Please hand over the case diary.
Well,
when the matter was last taken up on the following order was passed. Evidently, on 16/10/2023, this court was not inclined to grant bail to the petitioner. However, it was adjourned at the instance of the learned counsel for the petitioner. Learned,
pardon.
Therefore, the prayer for adjournment of the prayer for adjournment is rejected. The learned counsel for the state
material against the petitioner is, my lord, based on recovery of the chundri by which he has strangulated the deceased. Well, that has been recovered at the instance of the petitioner under section 27 of the Evidence Act. And also last scene, when she was deceased was giving where both deceased and petitioner were taken going on the embankment of the canal.
Last chance.
Recovery of
after vacation.
And a postmortem report strangulation.
Though the learned counsel for the petitioner again and again submits that the matter may be adjourned. The learned counsel, additional standing counsel for the state, referring to the materials on record in the content in the case diary, opposes the prayer for bail. Having heard the learned counsel for the petitioner who seeks adjournment, the learned additional standing counsel, considering the material on record contained in the case diary, this court is not inclined to grant bail to the petitioner at this stage. The same stands rejected and dismissed at this stage. Yes. Trial has not begun.
No, trial has.
Yes.
18.
May I please, your lordship, my lord?
Yes.
My lord, this is a bail matter, my lord. Present petitioner earlier released on bail. Subsequently, on 2012-2008, was taken by the present accused non-bailable warrant issued against him. After issuing the immutable, present petitioner now in custody My lord, custody since
Already in this case, our file is misplaced. Lordship, kindly be taken up on the reopening.
You have not received instruction.
My lord?
You have not received instructions.
No, my lord. Record is not received. In the meantime, I'll take steps to obtain instruction, my lord, whether it is on record or not.
No, what do you mean by bail jump? I could not get you, sir. What do you mean by bail jump? I could not get you. What is your submission that bail jump matter?
my lord, present petitioner earlier released on bail in same case, my lord. After
Default bail or what kind of bail?
default issuing NBW.
Default bail it was granted. Charge sheet was not submitted.
No, my lord. Present petitioner earlier released on bail.
By which order? By which court?
My lord, Court of Session Judge Baleswar. Subsequently, present petition was absent trial issuing NBW. Trial summary absent rohila. যেটা কি NBW ହେଇଯାଇଛି.
But yes, kindly speak to the microphone. Your sentences are breaking.
मतलब
trial summary.
Trial period रे present petitioner absent rohila.
So he was granted bail by the learned court in session of the matter.
मतलब adhoc additional district judge fast track court बालेश्वर. तो bail थिला.
My lord, here what I understood, my lord, he was on bail. He was on regular bail. Thereafter, my lord, he absconded. He didn't appear and NBW was issued. Subsequently, in view of NBW, my lord, he was arrested. Then he moved the bail before the Lord Court below. That has been rejected on the ground that he had not cooperated with the trial. For that has been
so
delayed.
Then, if he's in custody, then why he's not being examined? This plea becomes very onerous. That till he is examined, he will be kept behind custody.
No, because he was not cooperating with the trial.
So at least he can be granted bail with local surety and all that.
Lordship.
Because you see you say this is an year-old case. What the learned additional ad hoc additional sessions has rights. Of the year 2004, out of 18, 10 have been examined. Victim has not been examined. The trial of the case has suffered due to non-appearance of the present accused. When he did not when he did not appear, and what was the date of his non-appearance?
That has not been.
Nothing has been stated.
He was on bail, Lordship, but stringent condition must be there by which his procurement can be ensured.
Yes. That is in fact the learned court should have done that. Or if they want to be in custody till he is examined, then it is the onus is on the prosecution and the court.
Yes.
If you say that I want to examine or we want to produce him and he is in custody, the same day he could have been examined or the next day he could have been examined also. Mr. Maji.
My lord.
Mr. Jayanta Kumar Maji for the petitioner, Mr. S.S. Mahapatra, Additional Standing Counsel for the State. In response to the order dated 22/9/2023, report has been furnished 22/9/2023, 13/10/2023. Report has been furnished by the in the report dated 18/10/2023 by letter number 425 from the ad hoc additional district and session judge into bracket FTSC, the following has been stated. In this regard, it is most humbly stated that is at flag R up to further hearing. This case is posted to 14/11/2023. The learned counsel for the petitioner submits that the petitioner was granted bail by the court in session of the matter, and in certain occasions he did not appear before the court and thereafter he has been arrested and is in custody. The reasons of rejection stated in the order dated 22/7/2023 of the ad hoc additional session judge is that pursuant to the execution of the NBW, the petitioner was arrested in 2023 on date kuntu 22/7/2023. Para. However, the order doesn't indicate that after his arrest, what steps were to be taken for his examination and oblique or cross-examination. The reports also doesn't indicate any steps taken for examination of the said charge sheeted. He charge sheeted as accused of the petitioner. Petitioner as accused, as a charge sheeted accused. The learned additional standing counsel, referring to the materials in the, on record, opposes the prayer for bail. However, it is not disputed that however, comma, it is not disputed that the trial has progressed substantially. Out of 18 witnesses, only 3 witnesses are yet to be examined. Para. It is submitted by the learned counsel for the petitioner that the petitioner shall abide by the terms and conditions that would be imposed for grant of bail. He shall subject himself to the jurisdiction of the learned court in session of the matter and cooperate in appearing before the learned court. Para. Having heard the learned counsel for the petitioner, the learned additional standing counsel for the state, considering the material on record, this court is inclined to grant bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter for ensuring his presence. Which shall also contain a condition that any deviation from oblique violation of any of the terms and conditions shall result in the filing of petition for cancellation of bail by the investigating agency, oblique informant, oblique victim, disposed of accordingly. Yes.
19.
May I please, your lordship?
Yes, please.
Yes, lordship. I'm filed the
affidavit for
the case.
Affidavit is that?
Yes, lordship. That case is 420. 294.
You have filed an affidavit, Anindita Purohit.
Yes, the petitioner's wife.
No, there is an affidavit.
Let's see. Lordship directed on 17th.
Well, pen affidavit you want to withdraw.
Yes, your lordship.
So that cannot be withdrawn by a memo. Affidavit can only be withdrawn by affidavit.
That also.
So please, sir, be conscious of the procedure and the seriousness of the matter. You have to obtain another affidavit. Here, what you have done? You have filed another affidavit.
Yes, lordship.
Dated 1810.
Yes.
So 1810 affidavit, you should mention that I am withdrawing the affidavit. It's a simple one line, you have made it so big. Your name, sir? You are Mr. Mahapatra.
Sujit Kumar Swai.
Mr. Sujit Kumar Swai for the petitioner. Mr. Additional Standing Counsel for the state, Mr. Sushanta Kumar Lenka for the informant. The learned counsel for the petitioner refers to the affidavit dated 18/10/2023 filed by Srimati Anindita Purohit, wife of so and so, resident of so and so, regarding withdrawal of the earlier affidavit That has also been mentioned in the memo filed by the earlier affidavit dated 10-10.
Yeah, Lordship.
Dated 12-10.
Yeah, Lordship.
12-10-2023. A memo has been filed by the learned counsel for the petitioner dated 18-10, seeking to withdraw the affidavit dated 12-10-2023. Prayer is allowed. The affidavit dated 12-10-2023 shall be treated to have been withdrawn and be kept separately from the main case brief. Para. The learned counsel for the, as prayed for by the learned counsel for the petitioner, the affidavit dated 18-10 is taken considered. Yes, it is submitted by the learned counsel for the petitioner that the petitioner has been advised to take steps in terms of the affidavit dated 18-10-2023 at paragraph 2, which indicates the following. Quote paragraph 2 of the affidavit dated 18-10-2023. Copy of the affidavit has been served on the learned counsel for the informant, the learned additional standing counsel.
Fresh affidavit, earlier affidavit.
18-10.
18-10.
Yeah, Lordship.
Serve it now.
Service already did it.
So when you are bringing in the court in the last moment, so you are filing it in, just show him at least so that he can go through that.
No, 18-10.
You show your affidavit 18-10. You see, today is 19.
Yeah, Lordship.
So he cannot get that because you are filing in the filing counter. Show that affidavit to him.
Again. Yeah.
Para 2.
Yes, madam.
So Mahapatra, see paragraph 2 of that
Yes,
affidavit
yes.
filed today. Just go through the paragraph 2. The next, this is the second page. It starts with page 2.
Yes, ma'am.
Correct. The learned counsel for the informant. You have received the copy.
Yes, madam.
Yes. The learned counsel for the informant opposes the prayer for bail. The learned standing counsel referring to the material contained in the case diary opposes the prayer for bail. The learned counsel for the petitioner submits that the petitioner shall abide by the terms and conditions that would be imposed for grant of bail. He being a local person, having roots in the society, shall subject himself to the jurisdiction of the learned court in season of the matter. It is further submitted that as undertaken in the affidavit at paragraph 2, shall be complied with by the petitioner. Having heard the learned counsel for the petitioner, the learned additional standing counsel for the state, the learned counsel for the informant, considering the material and record, and the affidavit dated 18-10-2023 filed on behalf of the petitioner through his wife, this court is inclined to grant bail to the petitioner, subject to the stringent terms and conditions that would be imposed by the learned court in season of the matter, along with a condition in terms of the paragraph 2 of the affidavit, as the affidavit shall be, copy of the affidavit shall be produced before the learned court in season of the matter, when the prayer for bail is moved. Para. The condition for grant of bail shall also include a condition that any deviation from public violation of any of the terms and conditions shall result in filing of petition for cancellation of bail by the law enforcement agency, /informant, /victim, disposed of accordingly.
The date, my lord, after his release, the first installment, what he says, that may be mentioned, my lord, with
no, because that is to be imposed by the learned court. The learned court in season shall have the liberty to hear the learned counsel appearing for the parties.
Yes, ma'am.
Yes, including the public prosecutor.
22 also same. Yeah, Lordship. Item number
affidavit date कौन है तो भूल भाल
No, affidavit same day this 18/10 रे.
12 has been withdrawn or 12 is there or 1810
बात तो ये लॉर्डशिप withdrawn.
item how much which item 22
My lord. 22.
22 yes Sujit Kumar Swain
Yes.
so Sushanta Kumar Lenka yes same appearance you have filed a memo
Yes, lordship.
yes 1210 then 1810 memo then affidavit dated 1810 also this paragraph 2 everything same but draft after you prepare a draft show me yes
My lord, 50% at the time of release कर देना थे.
no you see you the problem is that these are very stringent terms and conditions actually please appreciate that I mean
My lord, one let indicate similar coordinate based my lord fixed condition that 3 installment. Similar case रे हितला.
no you see I'm not working out the exact order so that is how I have said that you please make your submissions and he is not in any event is repaying to you please appreciate that also so whether he is repaying in 3 installments or 4 installments it will be going to the current account of the court
My lord.
yes
item 20
May I please? May I please, your lordship?
yes please
Sir, here the petitioner has been implicated on section 302 of IPC, my lord.
yes
Fact remains, my lord, the petitioner is a physically handicapped person, my lord, disabled person. But allegation is that the deceased in a drunken
used to he used to actually tease him
my lord.
Yes.
so you have you gone through the depositions
Depositions I have gone. Most of the witnesses turned hostile.
and that incident is at midnight
Yes,
Midnight.
Midnight. It as per the IO statement, that is at midnight.
yes
And also,
so then how others could see him or no one has seen him only circumstances
as per our record, prosecution record, my lord, when brother came, having heard from wife at midnight found husband is lying dead. Then she made holla and younger brother of the deceased came. He asked the petitioner, have you done anything? He confessed. That is also the PW8's
so extrajudicial confession
but that has been in fair. I'm submitting a lot. The IO submitted what lordship on the last occasion had made query of this. He is a cripple and he is unable to. During my investigation, I inquired into the matter and he is a cripple. He is unable to move. Lordship, kindly see the deposition.
no because the prosecution story is that the accused
Yes.
went after the deceased that is how I asked you
Yes,
Mr. Himanshu Bhushan Das for the petitioner
but with my objection, lordship.
yes of course because you objected it was urgent
My lord.
so Himanshu Bhushan Das for the petitioner Mr. S.S. Mahapatra additional standing counsel for the state. The learned counsel for the petitioner brings to the notice of this court regarding the prosecution allegation, which also states that the petitioner is handicapped and is unable to move.
He is mentioning like this, means the accused is physically handicapped and he cannot walk properly as a normal man.
He's unable to move as far as locomotion is concerned.
Yes.
It is further submitted that there is no direct evidence as far as the allegations are concerned, and the entire case has been based on circumstantial evidence as per the statements of the other witnesses. In terms of the earlier order dated 17/10/2023, the depositions of the PW's prosecution witnesses 2 to 11 were copies of the depositions were furnished to the learned counsel for the state so as to enable him to go through the same. The learned counsel for the state opposes the prayer for bail.
particularly
Para.
on the ground, Lordship, may mention taken to the deposition of
No, because that will
Yes,
prejudice the
Lordship,
trial.
Lordship.
That will prejudice the trial.
Prejudice, yes, ma'am. Lordship.
Having heard the learned counsel for the petitioner, the learned additional standing counsel, considering the material on record, particularly the physical condition of the accused regarding his locomotor disability, regarding his disability, no prefix. Regarding his disability, this court is inclined to grant bail to the petitioner, subject to such terms and conditions that would be imposed by the learned court in session of the matter. We shall also contain a condition that any violation of any deviation from any of the terms and conditions shall result in filing of petition for cancellation of bail by the investigating agency. Yes, please.
Item 21.
May I please, Your Lordship. Connected matter has been disposed of, my lord. Pursuant to the order dated 16/10/2023, the registry has put up the explanation furnished by the superintendent, bail-Roman 2 section. The concerned ASO, bail-Roman 2 through the learned deputy registrar. Para. In view of the explanation submitted, the matter regarding not indicating the connected BLAPL in the connected BLAPL as required stands closed. Para. However, para. It would be expedient on part of the registry to ensure that by following a better procedure, such inadvertence is not repeated. Para. In view of the disposal of the BLAPL number 10536 of 2023 arising out of the same FIR, the registry shall take steps for listing of the matter before the appropriate bench after obtaining the kind orders of the Honorable the Chief Justice. Your matter, sir?
I am the informant, Derek.
Mr. Parthasarathi Naik for the petitioner, Mr. S.S. Mahapatra, additional standing counsel for the state, Mr. Muhammad Madani, Ghulam Muhammad Madani for the informant. Yes. Yes, please. 22, this along with that 19. Yes. Next.
23.
The registry has put up for consideration the letter dated letter number 37 dated 27/9/2023 from the learned First Additional District and Sessions Judge Khurda for extension of time for disposal of the ST case number 136 of 2017. Para. Having considered the letter, this court is inclined to extend the date for disposal of the ST case number till 26/12/2023. Yes. The order of the court shall be intimated to the learned court in season of the matter by the registry. Yes.
24.
Well, that has been disposed by earlier disposed of by
BLAPL. 23.
23. Yes.
So it is for extension of time.
Malad, disposed of by Malad.
Earlier order, I don't know.
Then Malad, that has to go before that.
For extension. Okay. For extension of time, since the earlier order was passed by, since the BLAPL was disposed of by the learned by a coordinate bench by order dated 1/8/2023. Since time was granted, like this, since time for disposal was granted by a coordinate bench by order dated 1/8/2023, the matter may be placed before the appropriate bench by the registry after obtaining kind of Honorable the Chief Justice.
Sorry.
Yes.
24.
Up to 24 to 33. Anyone appearing? Mr. 25, Mr. Mahendra Mahapatra.
Yes, Your Lord.
24 none appears for the petitioner when the matter is called. Mr. Standing Counsel for the State. To grant another opportunity, list on 28/11/2023. Mr. Mahendra Mahapatra. Yes.
Yes, 20.
You want time?
Yes, Your Lord.
Mr. Mahendra Kumar Mahapatra for the petitioner, Mr. Standing Counsel for the State, Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions and advance arguments as prayed for. List on 29/11. So, rest of the matters, maybe complete the proceeding and return to the registry.
May I pray? Lordship.
Yes, please.
There are many revisions, Your Lordship. 6 months, 1 year, and some fine, Your Lordship. Your Lordship may consider in respect of provision of Offenders Act.
No, I have been asking that, the Learned Counsel, that whether even the kind of a plea bargaining, that if the period already undergone, they agree. But I can't just.
Period undergone to hai nathibo, Your Lordship. Hai nathibo.
You are not getting, sir. In appeal, in revision, that order will be there. I have passed in one matter.
Yes.
Because there is a clear instruction that yes, he had undergone 1 month of incarceration and 80,000 he has paid. So I closed the matter by modifying that order. That period already undergone satisfies the punishment, and the compensation is 80,000. So I am not saying that the order is period already undergone. Please appreciate that.
Sorry.
You are thinking that if the period already undergone is already there, then I don't think any revision will be filed. In rarest of rare case, it will be filed.
Koti ବର୍ଷେ 6 ମାସ ଆଉ 500 ଟଙ୍କା ଏଇ ଟାଇପ
Here at least like yesterday, Mr. Parthasarathi Naik, he argued the matter immediately, impromptu. So I passed the order on merit.
Yes.
So that initiative has to come from the Learned Counsel for the petitioner. While adjourning, instead of adjourning, you say something on merit, it can be deliberated upon.
One thing, my lord, since my lord, we are going